Here to discuss the review by LMPD of the Office of Inspector General's case involving Omari Cryer. Accountability and oversight are extremely important to this department and this community and in law enforcement in general in order to build trust, and so is fairness and impartiality. Recently, the OIG made allegations related to the Omari Cryer investigations that we believe to be inaccurate. We take these concerns raised very, very seriously. It is equally important to ensure accuracy and that our officers are treated fairly. Let me be clear, when our officers do the right thing, I'm going to stand up for them. They put their lives on the line every day, and they serve this community with integrity and professionalism, and they deserve our support when their actions reflect those values. Transparency and trust are fundamental in us doing this job, and they're a very important part of external oversight. Last week, we met with Mr. Harness and a few representatives of the Civilian Accountability and Review Board, the Civilian Review and Accountability Board, to explain our position on the allegations they made and to notify him that we would be making our response public. So in sense, we gave him a warning that we were going to come forward with this and make it public. I felt compelled, due to the seriousness of this case and the seriousness of the allegations made, that we must make a public statement related to it. Myself and Mr. Harness, we all agree that oversight is important, and it serves an important role for us to function. And it's important that the public understands actions that the police department takes, whether they're good or bad, and they deserve to understand what our response to those actions are. We'll continue to engage the Office of the Inspector General in good faith with the expectation that accountability works both ways, that facts, not narratives, are the substance that builds trust. Our mission has always been protecting constitutional rights, the safety of this community, and the men and women who protect it. Considering the high-profile nature of this case, it's important to address it in order to address those concerns of both public safety and the constitutional actions that officers took. After this press conference, videos and documents related to this case will be made public for your consumption. So if we turn to the timeline on the screen, I'll give just a quick overview of how things happened through the course of this, because I think there's some confusion that it may be helpful to clarify. So the initial domestic violence incident takes place in January, and then there is an arrest warrant that is sworn out in March of 2022. And then the shooting involving Omari Cryer and the U.S. Marshals occurs in May of 2022, and then later the case is investigated by PIU, the Public Integrity Unit of LMPD, as well as it is then reviewed by the Office of the Attorney General. So, on January 23rd, 2022, a female called 911 stating her boyfriend was assaulting her. The female was able to flee from her boyfriend and run to a neighbor's apartment, only wrapped in a blanket and carrying her toddler son, who was in a diaper. And remember, this is in January that she runs out of the house dressed in this way, in fear for her life. LMPD officers responded and took a domestic violence report. That report in the documentation, or when you'll hear us refer to that kind of commonly as a JC3. That's a state standardized report that we take for domestic violence incidents. What you're going to see here in just a minute will be body-worn camera from the initial responding officers on that day in January. This video is about 7 minutes long, and it captures the victim's statements almost in total to the officers, at least the substantive parts of it.
I need to talk to you. What's going on? You need an ambulance or anything? Okay. What happened?
I was asleep and he hit me in my sleep.
Okay.
I'm like, why are you hitting me? He was like, when you're texting somebody else. Basically, I was texting someone else. He
Sure.
got upset and he pushed me into the wall and he just started beating me in my face and said he was going to kill me.
And that happened this morning?
It's been, what time is it? the lips and everything.
Sure, yeah, if you want to get the forms too, that'd be appreciated.
I just decided to let you go. I hurry up.
Has he been staying with you in that apartment?
Yes,
Okay. Has this happened before or anything? You guys have any kind of BPOs, DVOs, anything like that? You guys have any kids together? Hey, hi, buddy.
don't worry. You don't want me back home. It is cold. She's fast. The baby needs some help. Give me some clothes too. And grab my house shoes out of my room.
What's your last name, Mom? At any point did he strangle you or anything? Put his hands around your throat? He did? Like pushing his arm against you or around you? At any point did you lose consciousness? Did you urinate, defecate, anything like that? Felt like you couldn't breathe for a couple seconds? Did you feel like everything was going dark or no? Typically whenever people get strangled, we recommend that they go to the hospital and get checked out because they can have like secondary health problems. You know, you can get like a blood clot or something. You go home and then something bad can happen. Like a delayed effect type of thing. Would you like us to have EMS come out here? They're really just gonna ask you if you want to go to the hospital. So if you don't think that you're gonna go or want to go. Okay. All right. I have to go through this worksheet with you. There's a lot of questions I've already asked you for the yes or no stuff. At any point did you lose bladder control or defecate? Said no. Just a big, felt like you couldn't breathe for a little bit. Did you feel like everything was going dark? Okay. Did you actually pass out on the way or anything? Okay. Was it his right or left arm, you know? About how long do you think that it was happening? Like where he was trying to do? Okay. After he did it that one time, did he try to do it again or anything? Okay. Was he shaking you or anything while he was doing it? Did he hit your head against anything, any objects, the wall, the ground? Okay.
Yeah, just a lot. And then he took a little mirror I had to, make a line and slammed it.
Okay. Do you know if he's drunk or high or anything like that right now?
It might be high, but
Okay.
I think he might have smoked off sleep.
Sure.
Other than that, no.
Is he on probation or parole or anything?
I think so. Yeah.
Was he right-handed or left-handed?
Right.
Did he say anything to you while he had his arm around you? was his demeanor while he was doing it? Was he angry, happy? I don't know. Is there any other incidents of this happening? Do you have it right now? Are you having any difficulty breathing? You're not hyperventilating, but you're having a hard time breathing?
She said she don't have none, she got something for the baby, but she can't have none for you.
Tell her she has got something in her bag next to my bed.
She said in her bed,
She
next
has
to her
purple
bed,
pants,
some purple pants,
any kind of shirt.
any kind of shirt.
Are you having a hard time speaking or breathing, like talking, anything like that? You having any neck pain, feeling everything swelling? Your body
No, she
is.
ain't got no shoes. She don't want some house shoes.
So she can go down, she's like,
Under the bed, no, she ain't got nothing on.
You feeling dizzy? Do you have a headache or fainting? Like fainting? You're sleeping. Can you get that one? Huh?
So as you saw there, the officer responded, asked her a series of questions. Some of those were off the cuff. Some of those were him reading from a domestic violence form called a lethality assessment form to assess the level of danger that a victim might be in. Obviously, knowing that situations involving strangulation can be very, very dangerous and have later on consequences for that victim. So the case was eventually given to Detective Sarah Mantle in the Domestic Violence Unit, and on March 12th, she swore out an arrest warrant for Omari Cryer. I want you to understand the difference between an arrest warrant and a search warrant. An arrest warrant is to take a person into custody. It is the direct swearing to a judge of probable cause in order to take a person into custody, as opposed to a search warrant, which is evidentiary in nature, and it's built around entering or seizing property as evidence. And then a bench warrant would be that somebody's already committed a crime or been charged with a crime and failed to appear in court, and the judge then enters a bench warrant for that person's arrest. So we are talking about an arrest warrant here, not a search warrant that's been issued at this point. And so in the OIG's report, they allege that Detective Mantle made false statements about Mr. Cryer in that criminal complaint. And I'll quote here that the report states the following. Evidence shows Detective Mantle's criminal complaint contains false information. Detective Mantle's sworn criminal complaint states the victim began to lose consciousness when in fact the victim stated to responding officers that she did not feel like she was going to pass out. I think the video that we just showed is pretty unequivocal that the victim talks about being strangled for up to a minute and that she did begin to lose consciousness. She did later say that she did not completely black out, and the reason why those questions are asked in different ways is because victims have different experiences and different ways to describe their experiences. And I think you saw that the victim absolutely said that she was strangled and began to lose consciousness. And those charges are completely appropriate. And I will show you a clip of the video again where she states the affirmative as well as shakes her head in the affirmative that she was strangled.
At any point did he strangle you or anything? Put his hands around your throat? He did? Like pushing his arm against you or around you? At any point did you lose consciousness? Did you urinate, defecate, anything like that? Felt like you couldn't breathe for a couple seconds? Did you feel like everything was getting dark? No?
So at different points in their report, they question both the probable cause and the charges that were applied to Mr. Cryer related to this. And one of them that they point out, it says specifically the last charge, it did not appear the child of the victim or Mr. Cryer was assaulted, referring to the word minor at the end of the charge. So there was a misunderstanding by in the report that assault fourth domestic violence minor injury referred to assault fourth domestic violence of a minor child. The report states, quote, Detective Mantle added assault in the fourth degree, parenthetical minor. It is unclear what evidence Detective Mantle used to support the addition of this charge. Our office was unable to find any evidence Mr. Cryer and the victim's 2-year-old son was involved in the assault. Mr. Cryer was, in fact, not charged with assault of a minor. He was charged with assault fourth for his physical strikes to the victim here. So this could be resolved fairly easily by a better understanding of what this domestic violence charge actually is. That the word does not refer to a minor, it refers to minor injury in this case. And so here's the full text of the statute that's related. And this is probably the most commonly used charge in all domestic violence incidents is assault fourth. So the report goes on to state where it questions probable cause in general for Detective Mantle's arrest warrant here, and I'll quote again from the report. It is unclear to our office what Detective Mantle's probable cause is in supporting prosecution. LMPD SOP 8.6.11 states, the officer may apply for an arrest warrant when there is sufficient information to establish probable cause. A victim's lack of cooperation will not be a factor when seeking warrants. However, officers must have other evidence to support prosecution. Our office, referring to the OIG's office, our office has already established Detective Mantle's false statement regarding the victim's loss of consciousness on the criminal complaint. Our office also questions Detective Mantle's decision to increase the severity of Mr. Cryer's charges. And what this is referring to is the original domestic violence report had assault fourth. When the warrant was sworn out, the charge of assault second was applied. Understand that when these charges are taken to the court, it is consulted with a domestic violence prosecutor. And in this case, it was actually the chief domestic violence prosecutor at the Domestic Violence Intake Center, Jeff Metzmeyer. And the charge of assault second was applied because Mr. Cryer pistol whipped the victim in her face with a gun. Assault second is someone who inflicts injury with a dangerous instrument or deadly weapon, which is exactly what happened. So again, this is a lack of a clear understanding of the statute in this case. As far as the other charges, it's clear from the victim's statement that Mr. Cryer put his arms around her neck, preventing her from breathing to the point of beginning to lose consciousness. That meets the parameters of strangulation first. He threatened to kill her. You heard her say that he threatened to kill her. That meets the parameters of terroristic threatening third. And he punched her and hit her in the head with a mirror and pushed her against the wall. That meets the parameters and the requirements for assault fourth. So all of these charges here are appropriate. And I want to point out something beyond the fact that this case, prior to any charges being taken out, was counseled with the domestic violence prosecutor, but the detective in this case is actually a very prominent detective in the domestic violence world who helped write the state manual on responding to strangulations. She recently did a press conference with the Attorney General to release this. She is one of the best detectives in the state and assists other detectives on how to handle these incidents. So she is very, very familiar with these and cares very greatly about this type of work. So she understands what the requirements of the law are and what needs to be done in order to protect victims. So next we'll move forward to the day of the actual incident with Mr. Cryer. So the U.S. Marshals Task Force that involved probation and parole officers, state probation and parole officers, as well as members of Louisville Metro Police and the U.S. Marshals went to the address understanding that the person who lived at the address was on felony probation and that Mr. Cryer was possibly in this address. When Mr. Cryer left the location, he saw police and immediately fled from police. This is the video that was released several years ago. He immediately fled police with a gun, jumped a fence, picked up that gun, and was subsequently shot and killed by U.S. Marshals. After that shooting, officers from the task force, including the probation and parole officer, went back to the location to secure the apartment that Mr. Cryer had fled from in relation to this incident. The Inspector General report makes several allegations in reference to what is called a protective sweep. That is simply where officers go and secure the location pending the application of a search warrant. And so the property, the resident who was on probation was pulled out. It was explained to him what was going on, and officers went in and did a protective sweep. So there was questions about whether or not that protective sweep needed to be done or whether or not a search warrant needed to be done on that location at all. And I would say that considering that a person with a gun just left a felon's resident who is on felony probation, he pulled out the gun and was shot by officers, there's plenty of good justification to go back and retrieve any evidence that may be related to that incident. And so that's what they did. The probation officer went back, went with them to take part in that, explained everything to the person involved who was there. There was some question about the scope of the protective sweep being outside the legal parameters of what is allowed in a protective sweep prior to a search warrant. And I think this is one of the areas that me and the Attorney General can agree to disagree. That reasonable people can see some of these things in different ways. So I understand his concern there. I just fall on a different end of it when it comes to this. Officers are legally allowed, when there's reasonable suspicion, to assist probation and parole in those searches. The parameters of his probation allow probation and parole to enter his residence and conduct a search. And so that is what officers did. And so we felt that was perfectly legal in how that was done. The report refers to unexplained evidence that was found in plain view that was not on the officer's body camera. Understand that all of the officers from LMPD on this task force were wearing body cameras. The probation and parole officer, who is the one who stated that he found a marijuana bong, a scale, and a pipe, as well as smelled marijuana, he was not wearing a body camera. So we have no evidence one way or the other where exactly that was. And that was not part of the evidence that was sought by PIU in investigating this officer-involved shooting. This was simply for evidence related to the shooting, not necessarily strictly to evidence related to violation of his probation and parole. I think there's some room for improvement in our understanding and articulation of how we conduct protective sweeps, and I think we can do some work in that area. So that search warrant is sought. PIU, the professional public integrity unit at the time, investigated this shooting. Understand this didn't involve LMPD, but it was a shooting that happened in Jefferson County, and we took primary lead in that. And so they were assigned to investigate the case, and subsequently a search warrant, like I said, was drafted for that location that he fled from. The report makes some allegations that Sergeant Joel Cassie, who was in PIU and drafted the warrant, made false statements related to some of the statements that the resident made. So I will read again from the report. Sergeant Cassie stated on the search warrant affidavit that witness number one, quote-unquote, warned Mr. Cryer that probation and parole were on their way. Witness number one statements from his PIU interview does not appear to support witness number one warning Mr. Cryer. He simply told his friend what was going on and gave him the choice to go or stay. Now, if you were asleep on my couch and I wake you up and say the police are coming, they're about to come in and search my house, you can stay or go, I think any average person would consider that to be a warning. I don't think in any way implying that as an untruthful statement by Sergeant Cassie meets the smell test. And I vehemently disagree with saying that questioning this officer's integrity on something like that. If I tell you that the police are coming, I'm warning you. And that's pretty clear to me. Also understanding the consequences for police officers making false statements, particularly on search warrants, and in this community. We know what this community has been through, so to allege that LMPD officers made false statements in a search warrant or an arrest warrant that ultimately resulted in someone losing their life, particularly a black man in this instance, we know that has potential to be very, very destructive to this community. And so we take those allegations very seriously, and there was no such false statements made by Mr. Cassie or Sergeant Mantle. There were several other more administrative issues that were brought up in the investigation. Some were related to missing documents. The report refers to some missing documents, including the letter that is required to be sent to the victim when contact is not made. So the detective, Mantle, attempted to make contact via phone with the victim several times, and when she couldn't, she generated a letter that was sent notifying the victim that she was assigned to the case and how to contact her. This letter is done automatically through our system, and it is in the detective's tracking notes that that letter was created. So there was no missing document from that. There's also the thought in the report that the order to seal by the judge was not included, but it is in fact in the PIU case file that was turned over to the Office of the Inspector General. There were allegations of appropriate action regarding the amount of time that it took to investigate this case. So obviously this initial incident occurs in January. The warrant is not taken out until March, and ultimately the shooting doesn't happen until several months later. I will 100% say that that is something that we are very frustrated about too. This has nothing to do with an individual detective. When you have a caseload of 25,000 domestic violence incidents in a year, first of all, it's pretty sad for our community. But second of all, it does create a backlog, and that domestic violence unit that handles felony cases has to triage those cases and make sure that they are dealing with those appropriately, and everything that goes along with that, between calling witnesses, conducting follow-up interviews, going to trials, which this detective had a trial in the middle of this incident. And so while I'm not happy about that, I understand it, and that's something that systemically as an agency we do need to work on. The failure to make a supervisory review, our policy requires that a supervisor review each case, each open felony case after 60 days. When she takes the warrant to the prosecutor and seeks those charges, that supervisor is notified of that process. So there was some review that happened early on. The sergeant's notes reflect that there was a review done. However, it does say that that was done at 61 days, or at least it's notated at 61 days in his case file related to that. There was some questioning of the sealing of the search warrant. Again, this is another place where when I talked to Mr. Harness, it's a place where reasonable people can disagree. He questioned the need to seal the search warrant, and I understand that. I do think that this is an investigation sensitive enough that the need to seal is appropriate in this case, considering it involves federal agencies, it involves multiple other agencies, and the sensitive nature of an officer-involved shooting. Also understand that since this time period, unrelated to this case, our protocol in working with the Administrative Office of the Courts has changed, and any warrant that is sealed is automatically unsealed after 60 days unless the detective that's managing the case goes back to the court and seeks an extension and the judge grants them that extension. So there's another allegation about not following SOP when it comes to notifying the resident prior to the search warrant. Our policy says that the resident should be given a copy of the search warrant prior to its execution. However, in this case, he was given the actual paper copy of the warrant after the execution of the warrant. That being said, he had already been pulled out of the house. He was talked to about probation and parole. Everything that was happening, including the seeking of the search warrant, was explained to the subject prior to, so there was no attempt to hide, obfuscate, appear to not be doing what we were doing. The resident was completely aware of everything that was occurring and ultimately did leave with a copy of that search warrant. There was also the indication that this task force should not have been going after someone who did not have a known gang history and only had domestic violence warrants. I will tell you this. When somebody commits these types of crimes, I don't care who locks them up, as long as they get locked up. So whether it's the U.S. Marshals, another agency, or LMPD, I just want these people locked up and taken off the street. That being said, the task force mission that is placed in the OIG's case file is not a limiting feature in the way that it's described. It's not limited to gang members. And it does, in their scope of operations, talk about targeting violent gang members and working on felony cases that meet the criteria of homicide, kidnapping, assaults, threats, cruelty towards child, spouse, including weapons offenses and crimes against persons. Mr. Cryer met that criteria. And like I said, if it was a random officer on a traffic stop, this would have been a valid use of their time, was taking him off the street. So it doesn't matter who executes that warrant as long as he is taken off the street and that warrant is served. I think when it comes to the EMS response time and how long that took, I think there's a misunderstanding here. The policy that the OIG applies to this, saying that he states that EMS should have been put on standby, means they should have been sitting a block or two away and waiting for officers to ask for them to respond to this specific incident. That policy applies to search warrants. Like I said earlier, a search warrant is to enter a property in order to seize evidence. That was not what they were there for. They were there for an arrest warrant. Arrest warrants get served all the time on people. If we had EMS following officers around who were attempting to serve arrest warrants, EMS would never respond to anything else. There are hundreds of active arrest warrants on any given day, and so I do appreciate that some arrest warrants are all not made equally, and so some are more dangerous than others. That being said, there were 2 medics assigned within this task force that were able to act almost immediately after the shooting of Mr. Cryer and give him medical attention until EMS was able to arrive on scene. There was another administrative allegation related to body-worn camera categorization. This is kind of wonky, but there are ways within our system that officers label videos that make them harder or easier to find. It also sets retention times. And the report points out that videos, when improperly categorized, can be difficult to find. And it includes a screenshot of videos and the way that they're categorized, and they did not have IDs. Those videos that are included in that report are not related to this particular incident. The policy at the time only required categorization, which means it's labeled as a felony or uniform operations or that type of stuff. It did not require a report number or a description of the event. That being said, there are over 126 videos related to this event in the PIU file, and they are all labeled with the PIU report number and a description of the event. So, but to the point of the OIG, that policy had also been changed in the interim and now requires the report number to be on there in order to make sure that it is easier. So again, it's a misunderstanding of, I think, what they were looking at that particular time. And then lastly, there was questions about the failure of officers when they were chasing Mr. Cryer to make their intent to arrest known. So law requires that we make our intent to arrest known. There is a reasonability standard that is built into that. Mr. Cryer fled immediately upon seeing easily identifiable police. These are police in vests that say police across their chest. He knew exactly what he was running from, and he knew he needed to stop. The priority here was the safety priority of officers when a subject running from them for felony charges pulls out a gun, and that becomes the priority, not giving a verbal announcement to the subject that they're under arrest. There's a practicality issue there, and that just comes with real life experience and understanding the dynamics of how quickly these things happen. There's a huge concern of mine that occurs that is documented within this section related to the notification of arrest. The resident of the location who was on parole or probation was interviewed about this incident, and there's a quote included in the OIG's report, and I'll read from it. It says, witness number 1 stated, growing up in Louisville, you learn young, if someone jumps out and starts running at you with guns, you run. Witness number 1 ended the thought by saying, Omari was just walking while black in Louisville. That's why this happens. I don't know why that quote was included in there. He is not an eyewitness to this shooting. He was still in the apartment when the shooting happened. He is not a fact witness to that particular portion of the case. He doesn't know whether or not police said anything to Mr. Cryer because he wasn't there. He is not a subject matter expert on the law, our policy, or police tactics. The implication that race played any role in this, I have no clue why that was put in there. But I think it is an important thing to point out that this has nothing to do with race. If Mr. Cryer had not beaten his girlfriend, had not hit her with a gun, had not strangled her, had not run from the police, had not pulled out a gun, Mr. Cryer would still be here today. This has zero to do with him being black. This has everything to do with Mr. Cryer's actions. And it disappoints me and it upsets me that that type of implication is made in connection with a case like this that's so serious. That is not an accusation to be thrown around easily. And there needs to be evidence that supports an accusation like that. This man's words, he's entitled to his opinion, but it has no weight and no bearing on the actions that occurred on that day. And I see no reason for that to have been included, and I see no reason for that to influence the outcome of this report. It's okay for there to be a healthy tension between us and the Office of the Inspector General. They are oversight. I trust them to get this right. This community needs them to get this right. It is a difficult task to build trust, particularly in this community after everything that we've been through. And I think everybody knows how difficult it's been over the past few years. We need the Civilian Review and Accountability Board, as well as the Office of Inspector General, to help us in that. When we do things wrong, point it out. But when we don't, there's a responsibility to make sure that the truth is revealed in a fair and impartial way. Know that when the men and women of LMPD do the right thing, they deserve our support. And I'm going to give it to them. I would not normally come out and try to refute any of his allegations. I would look into them and we would move on. But this is pretty inflammatory, and I think it's appropriate that we address it this way because The officers of LMPD, the U.S. Marshals, and Probation and Parole were absolutely out there doing the work that we need officers out there doing every day. And I need them to know that they're going to be supported when they do the right thing, even when tragedy strikes. Unfortunately, our high times aren't always happy times. Tragedy happens at the end of many of our incidents. And officers need to know that when they're putting themselves in a position that might happen, that they have a command staff, they have an administration in the mayor's office, and they have a community that's going to support them through those types of incidents. So I'll open it up to questions now.
The Office of Inspector General has made recommendations many times in the past. Could you articulate again, just in the whole of what this report had, why was such a public response from you necessary?
So the question was, this is not the first report issued by the Office of Inspector General. They've made recommendations in the past, so why respond on this one when I haven't responded on any others? This was a high-profile case, and it was one that involved the loss of life. It's one that ultimately changed federal policy with the U.S. Marshals that prompted then-President Biden to force the U.S. Marshals to begin wearing body cameras. This is a case that upset many in our community, and they deserve to know the truth. And the officers that were involved in this performed well. And I can't sit by and let inaccurate accusations and characterizations of their performance go unanswered. There's a time and a place to answer in silence and behind the scenes, and there's a time and place when you have to speak up. And the consequences for this community and for these officers are enough that someone has to speak out on their behalf. And so that's why we're here today.
You've shown evidence of things that seemingly contradict what was in that OIG report. Why do you believe, if that existed, that these allegations were made by the Inspector General?
So the question was, why do I believe these allegations were made by the Inspector General if there was evidence that seemed to contradict it? It seems pretty clear. You know, any answer I would give would be speculative, but I think some of it has to do with a learning curve that hasn't been steep enough yet in some instances about internal operations to LMPD, internal operations to the way the criminal justice system in Jefferson County works. And I have some other opinions that I will take up again directly with Mr. Harness, but I don't feel that this wasn't a difficult case. It shouldn't have been difficult. There was nothing in here that was super controversial or hard to figure out. All it takes is a phone call in some of these incidents to figure it out. And just so that you all know, we have split our Special Investigations Division that used to house both PIU and PSU, the Professional Standards Division, into two separate divisions so that there is a major who is tasked with running professional standards but also being the liaison between the Office of Inspector General. That workload running both of those divisions was absolutely too heavy. So we split those divisions partially so that that major was more accessible to the Office of Inspector General. So a lot of these problems could have been alleviated simply by a phone call or Google.
And that kind of leads into my question is, can you, from your point of view, describe what the communication looks like between LMPD and the Inspector General's office when these investigations are being conducted?
So the question is about the communication when these investigations are being conducted. So some things have changed over the years and gone back and forth, and you know we have a memorandum of understanding now. But our primary point of contact for the Office of Inspector General is the major over the Professional Standards Division. So the need for documentation and things like that they might have, or general questions about operations go through that major. They have access to our videos and things, and if they have questions about, I know in this particular report there were some issues with navigating the reporting system. That could have been done very easily in an email or a phone call, and I know with some of the investigators it's done often, and those questions are answered and those things get taken care of. So the question is, what does the relationship now look like going forward that we've taken a public stance on this type of stuff? Well, like I said, I see the need for external oversight. I believe in the value of the Office of the Inspector General, as well as the Civilian Review and Accountability Board. I think they have a very important role to play in this community, and as the leader of this agency, it's important that we do what we can to make sure that they are putting out quality investigations and get the information that they need to be able to tell the truth to the public and give an accurate understanding to the public of what happened, what we get right and what we get wrong. And so we'll continue to work on ways to make sure this doesn't happen again. I think some light has been shed on both sides of this about the need to be much more aggressive in our attempts to work together so that this type of thing doesn't happen again.
So what's your hope moving forward?
My hope moving forward is that we have a functional system that they give us feedback on the places where we need to improve. And they point out those gaps, and they are that last line buffer. We need them to get it right. Need that feedback, and we need that functional relationship to work. And so I would say that my hope going forward is we get exactly that.
I know you disagreed with a lot of this. Were there any gaps you identified that you do want to fill?
So yeah, and some of that was, like I said, the gap about the articulation of the protective sweep and a couple of things. There are always going to be issues in every investigation, and so one of the things that we discussed previously that I need to step up on is at the end of their reviews of officer-involved shootings, what I had proposed to Mr. Harness several months ago was that we take the results of the PIU investigation, the results of the PSU investigation, the results of the Performance Review Board, as well as their review of our investigations, and we sit down and we compare and contrast so that we can see, how can all of us improve? What do we need to do differently in our criminal investigations, our administrative investigations, our attempts to improve training and policy, as well as how can we give feedback or get feedback on their investigations so that they can improve that process too. And that's on me to make sure that happens going forward, and we'll do that.
So will this investigation continue? Will any of these officers be investigated?
No, there will be no further investigations in these officers. These officers did nothing wrong, and they can rest assured that I'll give them a pat on the back for the work that they did on that day and the work that I need them to continue doing. So, thank you.